Hi, good evening, everyone, and welcome to this webinar. Today, we will be discussing on the basics of criminal litigation, IPC trial. Okay, so by the time Ravish joins and we begin with our session, I will, start with the little basics of what we are going to discuss today. One is that we all are aware that everything in the criminal litigation field, the procedure is governed by CRPC, which is the procedural law, which we have to adhere to starting from, filing our case to understanding the jurisdiction and everything. Every bit of criminal litigation has to be understood by CRPC. After CRPC, what we really need to understand is what is IPC, because IPC governs all the punishments and everything that is given there. Ravish, today here with us is a practicing lawyer. He has practiced in the criminal litigation for almost 8.5 years now. He has practiced with Advocate Mungekar, and he's regular at Bombay Bombay courts, especially at Bandra Court. He is regular there. He has his hands on 138 matters. He is experienced with domestic violence and all kinds of trial matters. Today, Ravish will discuss with us about how do you exactly, function in the courts. What are the practical difficulties a lawyer face initially in his careers? When we begin as a lawyer, as a beginner, when you start your career, trial court could be very complex. How do you handle those situations? Today, we will understand from the beginning to the end how a case is filed, how a case is concluded, why does Indian judiciary take so long to, give its judgment, and then why there are so many gaps in our system. Yes.
Ma'am, I have a question. Ma'am, I just wanted to ask
Yes.
how much relevance this session is going to hold for the first year students.
I think a lot of it, because I'll tell you why. Today we are going to understand what is the role of CRPC and what is the role of IPC. A lot of people don't understand the difference, and now since you are a first year law student, I think you will understand what is the basic, how exactly a case is filed and how exactly it is concluded. So I'm sure you will benefit from this session.
Okay, thank you.
Uh, can we going to discuss the technicalities of the criminal trials?
Yes, definitely. We will be discussing that. Earlier, Ravish wasn't here, but now let me introduce him again. So Ravish, like I said, has good more than 8 years of experience now. He has practiced in the field of criminal litigation. He is quite veteran with 138 domestic violence and other criminal matters. Today, Ravish is going to tell us basics of how exactly a matter begins and ends on the side of criminal litigation. What are the difficulties you face as a lawyer, as a beginner, and what are the steps that you should take early on in your career? And how do we go about it? So, Ravish, would you like to add something to what I'm saying, or we just begin with the question and answers now?
We would just begin with initially. We are here to discuss on the practical aspect of practice here, leaving bookish knowledge aside, and we are not going to get into sections and everything. We are going to go get into procedures and what are the practical difficulties in going about a case and how a trial begins and how does everything start.
Right. So, Ravish, tell me, today if there is something that happens, let's just say, a case where somebody does something illegal, and
Okay.
now I want to report it to the police station. So, how do I go about it? Let's just say that, I want to register a crime because I see a lot of ill things happening in my area. So, how do we go about it?
Basically, what happens is if a crime takes place and if a person directly goes to a police station, then basically first it's well and good if the FIR is registered. If not, because it depends upon the offense. If the offense is a non-cognizable offense, then the police will just file an NC complaint and the FIR won't be registered. So we have to see two aspects now, whether the offense is a non-cognizable offense or the offense is a cognizable offense. Non-cognizable offense are not that much serious in nature. But what happens if a cognizable offense has occurred and then too a police officer is not registering your FIR? That is the main question which arises, and it's a basic problem which occurs every time nowadays. So in such a case, a person is left with two options. One, he should file a written complaint and give it to the senior police inspector of the concerned police station. And thereafter, it gets marked to a particular investigating officer. And even then, if the officer is not taking any steps, then the same complaint is then forwarded, then it should be dispatched and given to the DCP, the ACP, the senior PI, and the commissioner of police. And what if again no steps are taken? Then a person is left with no option but to file a private complaint before the concerned magistrate court. And there are two ways now. If a private complaint is filed to register an FIR, then such complaint is to be filed in under section 156(3) of the CRPC. And the person filing it should seek an order from the magistrate to register an FIR in such offences. And now, if there are practicing advocates online also, they would easily come to know that there's a recent judgment of Lalita Kumari versus State of Bihar, which gives uh, certain directions and guidelines are laid down by the Honorable Supreme Court in that matter. Moreover, if that
Right.
that that way, if a person succeeds in getting his complaint registered, and that is the way of filing a private complaint also. If the concerned magistrate feels that no, there is no need of filing an FIR, so such complaint can be converted into a private complaint and a process can be issued under section 204 of the CRPC. Okay, hello.
Yes, we're listening,
Thereafter,
Ravish.
thereafter, coming back to the FIR, what happens when the FIR is lost?
Right.
Then there comes the stage of
So
bail.
Ravish, before coming to 156(3) and other procedures, I think a
Yeah.
lot of us here want to understand that. Okay, let's just say that today, if I see a crime, let's just say that something has something. Let's just say that, okay, I got into a fight with my neighbor where my neighbor has come and he has hit me. Okay,
Okay.
let's just take this example. My neighbor has hit me and now I want to report this in the police station.
Okay.
When I go to the police station people are not ready to take this case. My neighbor abused me, my neighbor has hit me, and now I'm trying to go there to the police station and I want to file and I want to register a crime against this person, but the police is not cooperating with me or the police is not registering the case. So how do you deal with the police as a lawyer? Okay, so if I'm going there and I want this crime to be registered, how do I go about it?
First, again, we have to see whether the crime which has happened and which has occurred is a non-cognizable crime or a cognizable. Because a scuffle comes under section at the most 323, which is again a non-cognizable crime. But what happens if there is a criminal intimidation and there is a house trespass? If your neighbor has come inside your house and assaulted, and then too the police is not registering the FIR, then again we have to follow the same process. If the officer, we first try to convince the officer. If he's again reluctant to register the FIR, then again we have to go about it in the same manner by reporting it to the senior officials. And then if again the no action has been taken, then to the court, because that is the only way how, if not registered, then it turns into a private complaint and a private complaint is filed before the court. So at least the culprits, the accused, are brought before the court and they are answerable to the charges. So the the only way if all the authorities are reluctant to register a case or an FIR. Yes, Ruchika.
Correct.
initially what happens is, this way, either through a magistrate or through an FIR, a crime is registered and the law is set into motion. Now, what happens is, there again comes a stage where the police officer, if he feels necessary that the person should be arrested, then he is arrested. If the offense is punishable under 7 years of imprisonment, and there after that the process starts of bail, and then after the bail, the entire investigation is carried out by the police officer, and by carrying out the entire investigation, on the completion of investigation, he files the final report, which is the charge sheet, which is under section 173 of the CR.
Okay. So, how long does it take, and how does a layman or how do we understand it? Which offense is cognizable, which is not cognizable? For which offenses can actually FIR be registered? So, how do we go about it?
For a layman who has or who's a person who's not a law graduate,
Yeah.
uh, a simple
No,
thing is that,
as a beginner,
there are,
obviously, we
as a beginner,
understand.
as a learner,
Yeah.
okay,
Yeah.
fine. So basically, what happens? Petty crimes are non-cognizable. Okay,
Okay.
and certainly, one thing which should be kept in mind is, we should always, as a law student, should
Right.
always see the offense, how much it is, the imprisonment is given in the IPC for that offense. Okay, so basically, what we learn is that offenses of, if it is of a not so much serious in nature. For example, there's a scuffle and there is a 323 case, or there's a normal criminal intimidation in which the person is trying to intimidate, and if certain offense which occurs, like an accident also, okay, and
Yeah.
which no harm is caused, fine.
Right.
It becomes a cognizable case, but it's not so serious that a person shall be arrested, and it becomes a
Okay.
bailable offense.
Okay.
Okay, so we have to see how these offenses are. As a law student, of course, we learn IPC, CRPC in our colleges, in our law colleges also, but then we have to
Right.
see practically how does it work.
Hmm.
Okay, so after that is the main aspect of criminal litigation, and a person who wants to practice criminal law has to
Right.
first see the practical aspect of the entire thing. Okay, so yes, it is sometimes very difficult also for a layman to differentiate what is a cognizable and a non-cognizable offense. In simple language, any offense, as we are taught in the law school, in which a police officer cannot arrest without a warrant, is a non-cognizable case.
Okay. So you're saying
Simple
that in
language.
matters where police cannot arrest without warrant is a non-cognizable
Yes,
and a
it
bailable
is
offense.
non-cognizable. It is
Yes, and
non-cognizable.
it is
There's no question
non-cognizable.
of bail. No question of
Yeah.
bail in this.
Okay, no question of bail in this, and also these crimes are not very severe in nature. It's
Yes,
not
not
a
seriously.
it's not a very big of a crime.
But
Okay.
but then you have an option of going to the court, approaching the court to register a private complaint, to accept a private complaint and issue process under section 204 of the CRP, so that, because many
Okay.
people would
So
say that a petty crime is committed. If a person has come, he has slapped me and no action has been taken against him, how is that
right,
possible? So
right,
it's not like that. If there is an
right,
MC also which is been lodged,
right.
so on the basis of that NC also, a private complaint can be filed before a magistrate.
Okay. So, how do we understand what is the procedure of filing a private complaint? How do we
Okay,
go about it? What are the practical difficulties that one comes across while filing a private complaint?
while filing, listen. Actually, I have to go and we have to see the entire problem. How it is how the courts are dealing with a lot of matters nowadays, and
Right,
courts are always giving priority to a police case. Okay, so
right,
nowadays
right.
it's getting very difficult to for a private complaint to be, first of all, a process to get issued in a private complaint. You can file a
Okay,
private complaint, but you have to keep in mind that yes, all the preconditions are being done in the complaint. For example, if you go
Okay.
and file a private complaint, there should be at least an NC, and thereafter there should be a reminder to the
Hmm.
concerned police authorities that his complaint was not taken seriously and cognizable offenses were not registered, and in turn an NC was given. And
Okay.
and it was not taken so seriously by the police officials, and that is why I have come before the court. And the offense actually took place. It depends upon the person who has to first convince the court to
Okay.
issue process under section 204 of the CRPs. There is a case made out. At this stage, while after filing and for issuance of process, only prima facie case has to be made out. We are not going to get into trial and the entire final arguments of the case. We have to make out the case prima facie before the court. If the
Okay.
case is made out, yes, process will be issued.
Okay. So, how do you, so let's just say that today I have filed a private complaint against
Okay,
my neighbor, taking the same example that he slapped me and he abused me today, and
okay,
then tomorrow I go to the court with the NC and other required documents and I file the complaint. And today is
okay,
the first day in the court,
okay,
okay? And the judge says that the matter is kept for admission.
okay.
So, what am I supposed to do as a lawyer on the first day of the matter?
On the first day of the matter, if your final prayer in your complaint, in your private
Hmm.
complaint, is just for issuance of process and not
Right.
for 156(3). So if it
Okay.
is for issuance of process under 204, then the first
Hmm.
stage is the verification stage. The
Hmm.
first date after filing is the verification of the complainant. That is under 200, section 200 of the CRPC, in
Okay.
which the complainant steps in the box and he narrates the entire incident, and
Okay.
which is recorded by the magistrate. And
So,
this is
in
how the verification is done. That is the first step of a private complaint if
okay.
the prayer is for 204.
So, Ravish, I also have a question here. So, when I say a private complaint, in the private complaint, can I just not ask for the prayers in the sense that, I don't want an FIR to be filed. I want the court only to conduct the entire matter. Okay. So, let's just say that it's not 156(3) matter, but it's a private matter, just like defamation. So, how do we go about a private complaint in this case?
Again, in such a situation, also there is one remedy which is available. Is that the court, if the court prima facie sees that there is something in the matter, then it
Right.
might order the entire matter for inquiry under section 202 of the CR. Then the
Okay.
matter goes for inquiry to the concerned police station
Okay.
in whose jurisdiction the incident occurred. And
Okay.
there is a preliminary inquiry. Both the
Okay.
parties are called by the police officer, their statements are taken, and there is a report under section 202, which is sent to the magistrate whether the case is made out or not. Okay.
Okay.
So after an inquiry, the police officer sends a report to the court, and if the report is positive, if the report says that yes, there's a prima facie case made out, then well and good. If the report says no, there's no case made out, and the dispute is, for example, of a civil nature, and there's no case made out, then
Right.
again there are ample of Supreme Court judgments which says that even though if the police complaint, if the police report is negative, then
Hmm.
also a process can be issued by a magistrate after
Okay.
for reasons to be recorded, and after being satisfied, yes, there was a case, well, prima facie case made out. Okay.
Okay.
So for a defamation case, as you said,
Right.
if a defamation has occurred, and it's important that after the incident there has to be a legal notice sent
Okay.
to the person who's done the act,
Okay.
and thereafter a private complaint has to be filed. So
So,
in the
just
same
like
manner, a defamation,
138 matter,
yes,
defamation
yes,
also has a mandatory procedure to be followed, which is sending a notice.
yes,
Um,
yes, it is. At
okay.
least, if not a notice, then a police complaint. but at
Okay.
least there should be a legal notice, or what you say, or there should be an ask for should be a person should be send a notice for an apology.
Okay. Okay, let's just say now, continuing with the discussion on the private complaint, now that the police report has come and now there is, a prima facie case which says that, okay, offense may have been committed.
Okay.
It is likely that the offense was committed.
Yes,
Now what
yes.
happens?
Then thereafter, the magistrate shall order issuance of process, like it is done in 138 also under section 204 of the CRPC, and summons are issued to the accused.
Okay. So the accused
After,
is then called to the court.
yes, and there has to be the service of summons which has to be done. And again, now most of the junior advocates at the start of their practice, they'll have to face a lot of difficulties in getting the summons from the court, getting it served, and
Okay.
thereafter getting the presence of the accused secured before the court.
Okay. So how do you get the summons served, if we may know in brief that how exactly is the court procedure about it?
A summons when issued in a private case, then actually once the order has been made, the person has to go to the advocate has to go to the concerned department of that court. He has to
Okay.
get that the summons issued by the court clerk, and then for service, the best way is to send the summons through registered post, so that
Okay.
there's a tracking ID on the India Post website which tracks your packet, so that
Okay.
if the concerned summon is received by the accused, it cannot be denied in the tracking ID in on
Okay.
the internet, and that report can be shown to the court for
Okay.
service, for a proper service to be made. Because if it says that a person now not at home, or
Right.
left the premises, left the place, then
Right.
the service is not done. If
Okay.
if there's a service made and it is sent to an accused and the accused denies and does not accept the summon, then also
Okay.
it's a good service. Then also it
Okay.
can be considered that the service has been made. So there
So
are
how do
many.
you intimate the court when the service is done? In a
If
case
once the
where,
service, okay,
yeah, so let's just say that summons was successfully served, and in a case where summons was not claimed, the parcel went to the accuser's house, but he did
it
not
was
receive it.
unclaimed.
Yeah, unclaimed. Returns is unclaimed. What do you do?
For that, the best option is getting the postal record from the internet, from the India Post website. That is why I always tell my clients to send the summons from registered post so that it can be tracked. Because
Okay.
unless if you send it normally by a courier service and there's no sign, they'll just write unclaimed and they'll send it back.
Right.
Even if, yeah. So that packet which is unclaimed, okay, signed by the postal officer, can be shown to the court that yes, we have served the summons, we have given intimation, but it was unclaimed. And
Okay.
unclaimed means good service. So that the next step would be that there'll be a bailable warrant issued against the accused
Okay.
for not coming
So,
before the court.
how much time does it take, practically for from filing of the case to issuing the summons? How much time, is
Basically,
elapsed
this
in the
is,
process?
yeah, this is a very common question, actually asked by
Yeah.
many people nowadays, that why does a trial take so much time, and why it happens in India that it takes 8 to 10 years for a trial to start. And we should
Right.
first basically understand that the daily board of a particular case of a particular court is so heavily burdened by
The trial
300
courts, you're saying. Yeah.
the trial court for
Yeah.
300 cases, 350 cases per day. So
Right.
now the court has to first give priority to a police case, and basically to a case in which the accused is an under trial prisoner. Okay, and thereafter certain priorities first are given to bail matters also,
Okay.
in which it is a question of liberty of an accused first. So
Right.
now what happens in private cases? if the matter is reached, and the board is so heavy, and for each and every matter to come, and that is why what happens is people can take undue advantage also by,
Right.
sometimes what happens is that the accused doesn't appear before the court and an exemption is filed on his
Right.
behalf, and there's a long date because the court is so overburdened, so a date of 6 months is given. So this
Okay.
is how this entire process gets delayed. Okay.
Right.
And for what happens is, once in a private case also, the entire process of, normally in private cases the dates are given, for longer dates are given, let's say
Okay.
4 months or 6 months.
Okay.
Okay. So after filing of the case in a
Mm-hmm.
trial court till the issuance of process, it might take a year.
Oh. Okay.
It might take a year also. And
Okay.
nowadays there are certain courts which are only assigned with specific 138 matters, in which only 138 matters are taken. Let's
Okay.
say in Mumbai, there are
Hmm.
separate courts for 138. So in that courts, the process is not that lengthier, and
Hmm.
it's not that long. In within 6 months, or let's say 5 months, the process is issued. So this is how there are certain, practical challenges also which an advocate has to face. An advocate has to obviously tell his clients, and the client might be anxious that, he has filed a case since so long and there's no action being yet not been taken in the case. So
Right.
these are certain difficulties which an advocate also faces while
Right.
handling the client. But this is how the
Right.
process is, because of uh, the heaviness of the board, and there are so many matters which are still pending. So that the pendency is main reason for delay.
Okay. Because the procedures are so lengthy and the possibilities
Of
that,
course, of course.
yeah, the court is always heavy on the board.
Yes,
Right.
yes.
So, one more point to add to what Ravish is saying. If you guys know, or so High Court board and a trial court board may have similar number of matters, but High Court does not necessarily complete the matters. There are a lot of time High Court spends the entire day on just doing two matters, but a trial court judge has to complete the entire board, even if it's just to grant an adjournment. So that is one of the biggest challenge which a magistrate has to face, and because the matter has to move, even if it's little bit of granting a date or granting an adjournment, a trial court judge has to finish the board.
Yes.
Yes. So, guys, all of you all have been writing a lot of questions. I am going to come back to the questions after we finish one entire procedure which Ravish has to discuss with us, and I'll definitely come back to the questions after that. So, Ravish, what happens after, let's just say the summons are served and now the accused has come to the court? What happens next? What is the next stage?
After the appearance of the accused, now it depends upon the offense. If the offense is, if it is a summons tribal case, then we have to
Okay.
understand what is a summons tribal case and what is a warrant tribal case. Okay.
Okay.
So if for a warrant tribal case, let's see if the offenses are of cheating and forgery, and the offenses are of serious in nature, more than 7 years the punishment is prescribed. In such
Right.
cases, in warrant tribal matters, there is a process called evidence before charge.
Okay.
Okay.
So,
So,
Ravish, sorry to stop you here, but I think it will be very clear if you give us example on, explain us with examples what is a summon tribal case and what is a warrant tribal case.
okay. All right. In a summons tribal case, in which the punishment is less than 3 years.
Okay, let's just
In simple
say
language, yeah, yeah. An accident case, in which,
accident case.
an accident case in which there's an injury to the victim,
Okay.
and even in cases of negligence, that is 304A of IPC. In that cases also, these are summons tribal cases.
Okay.
So what happens in a summons tribal case, and once the presence of the accused is secured, and the case is a private case, and in also a police case, which is initiated by a police report. What happens is after this, the plea is recorded. That is, the charges are framed. In
Okay.
a summons tribal case, we say that the plea is recorded, and the summons are issued to the witnesses. Okay.
Okay.
So once the summons are issued to the witnesses, the PW number one in a police case, it's a police witness number one, and in a private case, it's the complainant who
Okay.
comes and checks. In summons cases, the charges, the plea is recorded, and after, on the date, the accused is asked whether he pleads guilty or not. If the
Okay.
accused says, "Yes, I don't plead guilty," then the trial starts, and the summons are issued to the witnesses. In a private
Okay.
case, it is the complainant, and in
Okay.
a yes, and in a police case, it is the first informant, the person who
Okay.
opens fire and who's the first informant. So
Okay.
that's how the trial starts, and accordingly, the other witnesses are also called and summoned by the court,
Right.
and one by one, alternately, the cross examination, the examination in chief, and the cross examination takes place, and that is how the
So
evidence is gathered in a case.
okay. So if I say that I'm filing a private complaint in the court, domestic violence complaint under Domestic
Okay,
Violence Act,
okay.
it's a private complaint, right? So is this a summons case or it's a
No, no, a domestic violence case is a notice case, by the way. And what
okay?
happens is, in it is clearly stated that the magistrate in the act itself, that the magistrate shall lay down its own procedure. Normally,
Right,
yes, and normally the domestic violence case is conducted as per CRPC,
right.
that
But
is the
there is
Criminal Procedure Code.
to some extent the there are a few cases where the magistrate does go by the civil procedure code.
Yes, yes, it does. That
Yes.
that is why it is late. It is said in the act also. What if there is there's a specific there's an issue, and
Hmm.
and which has to be decided first whether
Right.
the entire case of domestic violence is maintainable or not. So
Right.
whenever the maintainability is challenged in a domestic violence case, the issues are framed like the
Right.
CPC, and
Right.
after the issues getting framed, there is evidence. And
Right.
after the evidence, that is the cross examination. If the complainant, if the applicant prefers to step in the box, and then the respondent, and
Hmm.
after that, arguments, and then the issue is decided first whether this present complaint, present application under Section 12 of Domestic Violence Act is maintainable or not. And
Okay.
once it is decided, if it is not maintainable, the entire case is dismissed. If it is
Hmm.
maintainable, then again the issue comes of interim maintenance, and then
Okay.
that's how the case goes on.
Okay. So coming back to like what you said that we need to understand the difference between summons tribal case and warrant tribal
And a warrant
case.
tribal case,
Okay. So summon tribal case could be 138 matter.
yes,
Okay.
138 matters are conducted as per summons tribal case. It is said that these are summary cases, and
Yeah.
which summary cases are those which are petty offences. But in
Okay.
case of Negotiable Instruments Act, the
Hmm.
entire trial is conducted as per summons tribal cases, and as the summons tribal cases are conducted.
Okay. So let me put it in this way. Now, if I'm taking 138 matter in my hand, so the first step is I filed a complaint in the court. I have after the complaint is filed in the court, today is the first date. I go to the court. I verify my all the documents with the with what I filed with the original document. That is the first stage verification. Now,
Very
along with my client, the first stage is done, the verification is done. Now, I think after verification, because it's a summary trial, a lot of courts emphasize that you file your evidence on the first day itself, that is after the verification. So let's just say that the first stage is done, verification is done. what is the next step now? What happens on the next date?
Uh, just now you said that there are some courts which say that the evidence shall be filed along with the verification. So
Right,
many a times
right,
the magistrate tells us that file the evidence along with your verification, and on that
right,
same day all the documents are seen, and then the process is issued.
right.
Okay, after verification and filing of evidence in a 138 case, then there's a argument on issuance of process. The court
Okay,
will hear the advocate for the complainant to
right.
see that prima facie this case is made out.
Okay, so let's just say the argument is done. After verification, the argument is done. Now, prima facie case
Now,
exists.
yes. Then again the same procedure. Similarly, summons are issued to the accused, and his presence has to be secured.
Now, the presence is secured. The accused is in the court.
It is,
Okay.
yes,
Now,
because as per the summons tribal cases, his plea has to be recorded, and
okay,
after the recording of plea, if he does not plead guilty, then the trial
right.
starts.
Okay. So I was saying that now that accused is present in the court, everything is done. Now the accused is present in the court. Accused pleads not guilty, and the trial begins.
Yes.
Okay. So now the trial begins. What is the next step that happens in the trial?
Okay. I think I got your question, Ruchika. That after the presence is secured and after the filing of affidavit
Yeah.
in lieu of the examination in chief, what is the procedure? This is your question, right?
Right.
So after that, the cross-examination of the complainant starts, and once the entire cross-examination is taken, and thereafter, first always the prosecution witness or the complainant witnesses are examined. The witnesses
Okay.
from the side of the complainant, or if in the police case, from the side of the prosecution. That is the state. And
Right.
after that, all the witnesses are over. If in a private case, all the witnesses are over, then the advocate of the complainant files a process for closure of evidence in which he says he writes and he says that all the evidence is over and there are no more witnesses he is going to examine. After the evidence, the formal statement of the accused is taken under section 313 of the CRPC, and thereafter he's been asked whether you want to examine any witnesses in your defense, and that
Okay.
is how the defense witnesses are called. So whatever he has to first give a list of witnesses of what all who all he wants to examine, and
Okay.
then the defense witnesses are examined, and after examination of the defense witnesses, there comes the stage of final arguments. That means now the entire matter has to be argued by both the parties,
Okay. So in
and then
this
thereafter
case,
it is, yeah.
is there any interim, amount which the accused has to pay here? Because now that there is latest amendment
Yes.
in 138 matters, how do you go about interim payment?
Interim payment, it's called the interim compensation amount.
Yeah.
Now it is specified that it should be maximum 20%.
Okay.
Okay, but for it depends. It's still the discretion of the court to
Right.
give the entire 20% or give something less than 20%, and it
So,
comes at the stage of appearance of the accused. Once the accused
okay.
has appeared before the court, then one shall make an application for seeking interim compensation.
Okay.
And it is the law now as per the new judgment of the Honorable Supreme Court. So the court shall give interim compensation, but the amount depends. How what is the outlook of the magistrate? What if it's a huge
Okay.
amount? Let's say the amount is of 20 crores or 30 crores, and 20% will be quite a lot. So in such cases, the magistrate,
Right.
after to be recorded, gives a certain amount as interim compensation. It may not be 20%. something less than that, but he shall give an amount as interim compensation.
Okay. So you don't have to argue anything before the court to get this interim amount, or there is some kind of argument, or there is some procedure to get
You
it.
have to make an application,
Okay.
because there are certain courts which, you know, in certain courts, it is a very administrative procedure that, if a person appears and a application is moved and the order is passed on the very
Right.
first day. But before
Right.
certain courts, you have to argue that,
Mm-hmm.
the entire case for interim compensation. And if the
Okay.
court thinks that, there are reasonable grounds that the entire 20% has to be given to the complainant, the court may pass an order.
Okay, so coming back to the main question here after our interim discussion, thank you so much on that. Now, let's just say that all the witnesses are examined, the cross examination and the examination in chief is conducted, and we are past that procedure. Now, what usually happens is that the lawyers submit their written notes of arguments.
It's always better to submit written arguments in 138 matters and private complaints. It is
Okay,
always good that one should give their memorandum of arguments for the final arguments,
okay,
so that, it's easier for the judge also. And
okay,
in a 138 case, it is for me, it is like necessary to give a written argument
okay.
at the time of final.
So these
You can
are
also
after.
argue orally
Okay. So in
even after
this,
giving it. Yeah.
so you are saying that
Yes,
in
Ruchika.
138 there is no framing of charge, or there is no framing of there is no framing of any issues because
No, no. There is recording of plea, which is, in other words, framing of charge. In a
okay,
summons case, how the plea is recorded and the person is asked if you plead guilty or not. So it comes
okay,
at the time of appearance of the accused. Once the
okay,
accused comes before the court, then the charge is framed, the plea is recorded.
right. So okay, now Ravish, we've understood that this is how a 138 matter is concluded. This is pertaining to how a summary trial would be. Now, let me, tell you that I have filed a case of 420 with a police station where, let's just
Okay.
say that I was cheated and I go to the police station. Now, my FIR is filed. There's a case of 428 which is filed. Now, what happens after a case of 420 is filed? With the police station. Now, what is the next stage after the FIR is filed?
In in a police case, once the FIR is registered, and let's say if it is a 420 case,
Right.
now there are certain guidelines earlier in which was laid down by the Honorable Supreme Court in DK Basu's case. What is and how? What are the procedure and how to arrest? What are the rights given to the accused at the time of arrest also? And then
Okay.
it was again confirmed, and it was again there was a recent judgment of Agnesh Kumar was his name, in which there
Okay.
were certain guidelines, of how to arrest. There's a section, certain notice under section 41A which has to be given, and 41A has to be complied by the police. And there's a certain notice which has to be given to the accused from the police station, that, there's a FIR registered against you and you are being called to the police station for investigation. And once if
Okay.
the accused appears before the police station, then it is after investigation and after his statement getting recorded, and if the case is of serious nature and
Hmm.
the investigating officer feels that the person has to be arrested for further information, then his arrest has to be made. And
Okay.
if after getting such notice the accused has an apprehension that I will be arrested, the accused
Right.
under section 438 of CRPC shall go for an anticipatory bail before the Honorable Sessions Court.
Right.
That is also a pre-arrest bail, or you call an anticipatory bail. So this
Okay.
is the procedure. After FIR, there's the stage of bail, there's a stage of arrest, and thereafter the stage of bail comes.
Okay.
And during this the entire process, the
Hmm.
investigation is started, and the investigation officer carries out the investigation carries out the panchanamas, he records the statements of the witnesses, he goes to the spot, he sees and he analyzes all the documents if it is a 420 and a forgery case. Okay, and after that, the charge sheet is filed under Section 173 of the CRPC, which is the final report of the investigation. The charge sheet is filed before the court.
Okay.
So this is how this
Okay.
is the stage after registration of an FIR. Bails is a very vast topic. When it comes to an anticipatory bail, how can the court give an anticipatory bail, and what are the reasons and what are the circumstances? It depends upon different cases. If it is a fit case in which the person can cooperate without getting arrested, and if that person is been cooperating since he was called to the police station, and he's been coming before the court regularly, and he's been not no participating in the investigation, then there are no grounds that his custody is required. In such cases, anticipatory bail is given.
Okay. Now, Shrishti is asking us a question. What is anticipatory bail? So, to answer your
Okay.
question, Shrishti, anticipatory bail is a bail where you are apprehending to get arrested, and you have the fear of getting arrested. And so, to stop that, you file an application before the court of sessions, like Ravish said, because court of sessions has the jurisdiction. You go before court of sessions and you file that this is the FIR that is registered against you, and you are apprehending the arrest, and then you lay down the reasons why you should not be arrested. I ask Ravish to add on to this.
Yes, Ruchika. Once the application for anticipatory bail is filed before the sessions court, the court on the first day may grant interim protection to the accused, so that on the very first day, if the matter comes up before the court after filing, the court shall seek the report of the police officer, that is the investigating officer, that till now what has happened, what is the investigation carried out in the case, and why the custody of the accused is required. So the presence of the accused as of the investigating officer is sought by the court on the next day, and also the report from the investigating officer stating that why the arrest is required in this case. And by that time, if the court thinks it is reasonable, the court grants interim protection to the accused, that so that till the next date no arrest shall be made.
Okay.
And after that, after the report which comes before the court of the investigating officer, and in certain cases the investigating officer is also called before the court, and after arguments, if the court comes to a conclusion that anticipatory bail shall be granted, the court shall grant anticipatory bail on such conditions that the accused shall attend police stations, cooperate with the investigation, and give all the documents which are required by the police, and not abscond from the jurisdiction of the police
Yeah.
station, shall not travel out of India. These
Right.
are certain regular conditions which are given once an anticipatory bail is granted.
Right. So, about bails and anticipatory bails, now Ravish has thrown some light and he's told us what is an anticipatory bail and what is a bail. Um, now, Ravish, again coming back to this, my FIR is lodged. My FIR. So this person, the accused, he's arrested, and the next day he's brought into the court. Now the bail procedure happens. Everything happens. What happens after he is granted bail in the matter?
After granting of bail, uh, Ruchika, there are certain guidelines. Again, the law says that charge sheet has to be filed within 60 days in cases which are punishable for up to 7 years, and then less than 7 years, and for certain cases like in which the punishment is more than 7 years, 90 days is the limitation of filing the charge sheet. In cases in which the accused is in the custody of is in jail custody, and what happens if the police does not file charge sheet within the prescribed time?
in a private complaint, say under section 420, is there apprehension
Yes,
of arrest at any stage? Is there arrest at any stage in a private complaint?
In a private complaint, sir, normally after issuance of process, the person comes before the court, applies for bail, and he is given bail. What there are certain aspects also in which that accused can be arrested in a private case. What are the circumstances if that person does not come before the court? Okay, and there's a non-bailable warrant issued against the person, and that
Okay.
in execution of the warrant, under execution of warrant, the person can be arrested, but other than that, in a private case, a person cannot be arrested by the police. Yes, sir.
Yeah, just related to say, we are saying that in a private complaint, the arrest, unless and until there is no summon, is not possible. But see, generally, when there is a complaint of 1563, it is between the police and the court. The complainant is not even called for, not given a chance even to defend himself or give his counterpoint of view. So, I mean, how you explain this position?
The accused, you're
Because
talking
he's not
about the
there.
accused. Between,
Yes,
so it's between the
yes,
complainant and the court. Yes.
yes. It is
Is,
complainant and the court.
is that the
He is
case?
not there. Yes. Police is
Yes,
doing the
sir.
investigations. It is just so he has no
Listen.
chance to defend himself.
Yes, sir. I'll come. I'm coming to that. What happens once the court even orders for an FIR to be registered under section 156(3), and that direction has been given and the FIR is registered. After that,
Yes,
the police calls the accused for investigation. Okay. And if
yes,
the officer does not feel after recording of his statement that it is
yes,
not necessary that he should be arrested. Okay, because there is a
yes,
chance for the accused at that time also that if the police has summoned him to come before him, the police station, that accused has a chance to go for anticipatory bail and to tell what he has to say before the Honorable Sessions Court that his arrest is not required and he's ready to cooperate. Did you get me, sir?
yeah.
And
I'm
on the
getting that.
other hand, yes, and on the other hand, he can also go appear before the police station, and if the after recording a statement by the police officer, if the police officer feels that there is no case made out, then he can file such report again to the court that the case is not made out after investigation, after recording of statements, and after due investigation. It has come out that certain case, let's say if a 420 or a forgery case, the case is of a civil nature, and such report is again sent back to the court. So
Okay.
again, you cannot say that 100% there are no chances for an accused to defend himself. I hope I have answered your question, sir.
No, you have answered, and you have answered very well. But yeah, I understand you being in practice for a long time. Police, in Delhi, especially I'm talking, there
Okay.
are rare chances of filing an FR. They keep on lingering. They keep on calling the police station. The case is not made, but they say they are under the pressure from the opposite counsel, etc.,
It's
etc.
the
It
same
goes on like
everywhere.
that. Yeah.
Okay. So your question is that hello, what if that
So
advocates don't suggest the
in
accused
court,
to go for anticipatory bail?
yeah, because if anticipatory is rejected, then you have no choice except
You have a
arrested.
chance to move. You have a chance to go before the Honorable High Court after the anticipatory bail is rejected before the Sessions Court. And
Mm.
people have this opinion also that High Court may give more understanding to the case and more time to the case, and there are high chances that High Court won't reject. Why is an anticipatory bail rejected if there is scope for investigation? Number one, scope for investigation with the person in custody. There are certain things which can be revealed and which can be discovered only if the presence of the accused has been secured and he is under custody. You got it, sir? So in such a case,
Yes, yes.
it depends upon the FIR and the case that, I mean, we have to give our opinion to the client that your case is very tough for an anticipatory bail. But still, we have no option but to go for an anticipatory bail to make the court understand. And we are not in an advocate never guarantees. We
Mm.
cannot guarantee someone. It's not the practice that you should 100% guarantee this thing and accuse that you will get a bail. You can of course give him confidence, But if you see that the case is not going against him, it is the job of the advocate to tell him that there are certain things which are going against you.
Yeah, thank you. Thank you very much.
Sir, I have the one question. Hello.
Yes, who's this?
Sir, myself
I think it's
Raj.
Raj.
Yeah, ma'am.
Yes, Raj.
My question is relating to bail matter, like 420
Okay.
and forgery. In this case,
Yes.
there are three accused, and two accused are already in magistrate custody. And previous year, third accused are arrested, and that third accused are also in magistrate custody, but they are not taking any anticipatory bail. In lower court, the bail was rejected, and session court also bail was rejected. The ground is if accused goes in society, they are tampering in evidence. There are chances. So
Okay.
third accused has to be apply for a bail in this matter because both one accused
So
number
you
one,
said
accused number
that.
two are rejected.
Okay.
Uh,
So I got your
both
question. Your
accused
question is that
to apply accused number three has to be applied that bill if that accused number
no. It
two
depends. It depends
has
upon the role of accused number
already
three. Yes, Raj.
is considered as the main accused has the main offense are created by accused number three.
Okay. The main offense has been committed by accused number three. You are saying that.
Yeah.
Hello.
Yes.
Yes, Raj.
Yeah,
Your
sir.
question is that the bail application of the other two accused, that the accused number one and two are rejected, and can you file an application for? You can always file an application, a bail application for accused number three. But what happens is now, what are the reasons? The reasons are that there shall be tampering of evidence. So the court also feels that at this stage it is a very preliminary stage of investigation if the charge sheet is not filed. That is why there can be chances of tampering of witnesses, because once the charge sheet is filed and all the witnesses have given their statements, and still there is a fear, then court shall put conditions for bail. That bail cannot, if bail is granted and if the accused is found tampering with the evidence, then his bail shall be cancelled. And but it depends. Now your question is that can you file it or not? I would still suggest that if there are grounds and good grounds that investigation is completed, and there would be no fruitful purpose or no purpose in keeping the accused in further custody, then you can always apply for bail. That is my suggestion, Raj.
Ravish, there is another question by Anchit. He says that I'm based in Calcutta and somebody
Okay.
in Delhi has cheated me, taken my money
Okay.
but not supplied the goods. Where will the FIR be filed? In Delhi or in Calcutta?
Where did the transaction took place?
Let's just say Delhi, but he's in Calcutta.
But the entire transaction took place in Delhi, and he went down to Delhi to make
Or
do the
if it
transaction.
of or if there was a wire transfer.
If it was a bank transfer from Kolkata,
Yeah.
then he can register an FIR in Kolkata itself.
Okay. Okay.
But then there will be a great difficulty in getting the accused to Kolkata.
Anchit says
Of course,
online, like I said. Yeah.
the FIR would be registered, but then there will be quite it will be quite difficult to get the accused to Kolkata from Delhi. It
Okay.
might take time.
Right. Krishna has a question.
IPC
Yes.
section 25.
IPC
I
section
think
425. It got disconnected. Anyway, so let's move on. What is the present scenario of somebody says that one primary question is, can police arrest immediately on receiving a 420 complaint at police station?
I said that there are certain guidelines laid down. Section 41A has to be complied with. and
Right.
a notice has to be given to the accused first. And
Right.
immediate arrest in a 420 case, that is the question, right, Ruchika?
Yes, that's the question.
In that case, 41A has to be complied. There cannot be an
Okay.
immediate arrest. And
Okay.
if there is an
41.
immediate arrest without compliance, without compliance and without giving a notice of arrest, which we call 41A of the CRPC, then it can be a ground for bail also.
Right. 41A is the latest amendment in CRPC, right?
Yes, after and it has been earlier also there were guidelines laid down in DK Basu versus State and then again in Agnesh Kumar also. So now this has been this
Right.
is followed by the police also. 41A notice has been given in all the cases nowadays.
Right. So we were discussing about the procedure that happens in court after the bail is granted, and now
The charge sheet
the
is
accused
filed.
is granted bail. Yeah, the charge sheet is filed. Now, what happens next?
I was on the point that what if the accused is still in magistrate custody or jail custody and the
Right.
charge sheet is not filed within 60 days or 90 days, then there is a process in which a bail application under section 167 subclause 2 of the CRPC can be filed, stating that the prescribed time of filing of charge sheet has expired and yet the charge sheet has not yet been filed. So in that case, a bail can be granted and bail has to be given by the court.
Right. I agree to that.
After that, after that, after filing of charge sheet, and let's say if the accused is on bail, now again it comes to the same question that why matters are getting delayed because that now the matter is placed under the caption of not heard cases. Okay,
Okay.
so the daily code of a magistrate court is classified, it is differentiated into there are three groups. One is a part heard matter group, the other one is a hearing matter group, and the third one is a not heard matter group. Okay, taking up matters which are let's say of the year 2010 and 12, and rather than taking up matters which occurred in 2019 or 20, because old matters are given preferences and the court has to prioritize and end those matters and which are lagging and which are still pending since 10 years, 15 years. And after that, after again the same procedure continues, Ruchika, after the
Right.
filing of charge, there is a stage of framing of charge in which the accused is asked whether he is guilty or not. And if he denies and that all the charges and says that I'm not guilty, I don't plead guilty, then the trial starts. And then the prosecution witnesses are called before the court. All the witnesses, one by one, that is the first informant in a police case, and other witnesses, the panchas, the people who are present at the time of panchnamas, or for recovery and for confession and everything. And at the last, the investigating officer is called. Investigating officer is always the last witness who has conducted the entire investigation. And thereafter, after the cross-examination, examination in chief, and cross of
Okay.
all
Okay.
witnesses, again the same procedure follows. That a formal statement of the accused under section 313 has to be taken, and thereafter defense witnesses are called if any, and then the final arguments, and then the judgment.
Okay. All right. There are a few doubts here from the students. I think I'll just read it out to you.
Yeah.
Raj says that he has internship in
Rishi, I
chamber
cannot
as
hear you.
well, where a lots of where I work on a lot of criminal cases. I'm going to court. I do the filing. I take summons. I take dates. I also do drafting of notice and application office. How do I prepare? How do I understand that? What are the practical difficulties? I think Raj, this is your question because Okay. So yeah, how he says that what is your advice to him? How should he, practically what are a few tips that practically he should adhere to?
First of all, I need to ask whether Raj is into criminal litigation or he's practicing
Yeah,
in.
he is practicing in criminal litigation, and he's asking you what should he
Yeah,
take
what?
care of while practicing.
Okay. Raj, I would just give you one suggestion that in order to understand criminal litigation, one has to spend time in trial courts like the magistrate court and the sessions court. Give more preferences to trials rather than doing miscellaneous work. But yes, initially we have to do miscellaneous work. We have to, as juniors, even I did the same thing. We have to, you know, get ourselves into, go and collect summons and issue warrants and services of summons and notices. But that has to happen. And initially for 3-4 years at the beginning, let's say 3 years, one has to practice all the entire procedures also, the administrative work. Like, this is how the practice starts. And why I'm suggesting that you should practice in trial court is to make your CRPC, uh, because it is CRPC is the base of practice. Okay, so in while practicing in trial court, your CRPC becomes strong because procedures are followed, what how it is cancelled, and what are the basic sections. Let's say even a filing of exemption and taking adjournments, it gives you practice in terms of appearance also, that you start appearing on a smaller scale, like filing an exemption and adjournments. But the exposure which you get, traveling to different courts and looking at your seniors, and or at the same time you should prepare, you should go through certain, you should be updated with new judgments, you should read books, read the all MRs and the law journals and everything. And you should at least try taking up, after certain time, try taking up trials on your own, and try taking up help of your seniors and try to conduct trials, because it is very important for an advocate to go into trials and start conducting trials. You can take on pro bono matters. There are many matters which under trial advocates require. Under trial accused are in need of advocates who can work for them, and they cannot afford a lot of money to give to an advocate. So you can, for a start, try taking pro bono matters, and which you can do it for your practice, and give your best on that matters.
Definitely, Ravish. Thank you for giving your insights on that. Raj, I was initially when I started practicing, I definitely would. Whenever I would go to Bandra Court, I would always ask Ravish. I'm stuck in this situation. What do I do next? We always had this situation, and Ravish would always help me out to understand what is the next procedure here. So it happens that you should be thorough with the facts of the matter. You should know when you are appearing, even if it's half an hour before the matter that you're given the brief of. You should know what is the stage of your matter. Who are you? What is going to happen next in the court? Are you supposed to file any application? Are you, because the judge is not going to know what your matter is for. You are going to appraise the court that, okay, this is the matter, this is what it is kept for, this is what happened on the last date. So these are the basics that you need to be sure of. And one advice that Ravish had given me when I had started with my trial court practice is that irrespective of the field of practice that you are in, you should be thorough with Evidence Act, because the Evidence Act is applicable in all the fields, all sorts of practice. So one is that you should always have 3 in 1. If you are practicing on the criminal side, you have to have CRPC evidence and IPC in your hand. You should know that you don't know who you will be appearing in front of. If it's just 45 minutes before the matter is going to begin, you get the brief, because this is how it happens. A lot of people don't have tabs on the matter, and you're going to be in such situations a lot of times. So yeah. Right. Ravish, there is another question. from Krishna. He says, in a private 420 case, at what stage can accused raise jurisdiction issue?
Krishna, in a private 420 case, jurisdiction issue accused can raise at the time of, once he appears before the court. And what, in certain cases, if the summons has been issued to the accused and the accused knows that there's a case filed against me, and he might, his lawyer can approach the court for certified copies of the complaint. Normally, it is the practice that along with the summons, the copy of the complaint shall be also supplied to the accused. So, on after going through the complaint, if the accused still feels that yes, there is a jurisdiction issue, then the accused shall immediately go and challenge the order of issuance of process of the magistrate court before the Honorable Sessions Court.
Okay, so Ravish, I will ask you for a little more clarification here. Let's just say that the matter has reached the stage of evidence, which is like the
Okay.
trial. Yeah, the trial is about to begin. The trial is beginning now. So, if at that time as a lawyer I realize that okay, the jurisdiction is incorrect, the jurisdiction is not right. Can I, at that point of time, at the time of evidence, can I now tell the court that this is not the proper jurisdiction?
You can always file an application challenging the jurisdiction at that stage, also giving reasons that why it was not in your knowledge earlier when the
Right.
case had come to you. And if the court is satisfied, then the court will take on the application, and after arguments pass an order,
Right.
definitely the court, if the jurisdiction point is challenged, and this court is not having a proper jurisdiction,
Right.
then the court may consider. But normally in a private case, before issuance of process, it is assumed that the court, after going through and applying its mind, has issued process. So if at all there is any issue of jurisdiction at that time, it shall come to the notice of the court at that time also. But in case if it doesn't, then you can point out jurisdiction issue before the court at that stage also, before at the time of evidence also. And
Okay.
for giving reasons that why it had not been challenged earlier, if the court is satisfied, then it can pass order. And there's always if the application is rejected, you can always go for an appeal before an honorable sessions court if you have a good case of jurisdiction.
Okay. I hope that answers your question. And so there are a lot many questions, but we are running out of time. So you can, maybe ask your questions to Ravish on LinkedIn. We have shared his LinkedIn ID when we did this. Now there is one last question which I'm taking up, which says, under which provision is jurisdiction challenged?
Ruchika,
Yeah.
yeah. So your question is that under what provision?
Yeah, under which section can jurisdiction be challenged?
It depends what case it is. What case
Okay.
in a private case or a police case, if it at all if it's a police case, then it can be a ground for quashing if there no proper jurisdiction was made, and without having any jurisdiction the police has arrested or lost the complaint. But coming to a provision as such, there is no provision. It's about
Okay.
it's the decision of the
So,
court, and it
yeah.
can be pointed out to the court anytime.
Yeah. Right. So, Ravish,
There
is there anything?
is a provision, but to challenge the jurisdiction, there is nothing as such.
Right.
It's the
Okay,
dispute
I got your point. It depends under which act you have filed your case.
under which act, under which
Yes.
case.
Yes.
Yeah.
Right, right. So, Ravish, I would like to conclude the session now. And is there something more that you would want to add, or you would want our, the people in session to know today?
I just want you all to know that in our law colleges we have certain acts are not before us at the time of studying and doing our LLB. Like the Domestic Violence Act is not there, the Negotiable Instrument Act is not there in our syllabus, and the Information Technology Act and the NDPS Act. There are certain minor acts also. So my suggestion would be that, and just that with your studies also, you all can at least go through certain acts like the minor acts, like the if you are intending to practice criminal jurisdiction, then you can actually go for minor acts, the Maharashtra Police Act, the whatever state it is, the basic police act also, and certain minor acts and negotiable instruments. And why I'm saying that, because as soon as you all finish your studies and you all are into practice, it should not be the case that these acts are very new for you all, and you all will take more time to adapt to these acts, because IPC,
Definitely.
CR, everything is there in the syllabus, but these acts are
Yes.
not there in the syllabus. So the
Yes.
only suggest that you all should at least go through such acts and but take it as an
Um,
hobby actually to start with a new act.
Right. So, Ravish, since we have 5 more minutes and people are already appreciating this session, and I completely missed out that most of your practice is between 138 and domestic violence matters. Now, I understand the
IPC.
difficulties. Yeah, IPC, domestic violence matters, and IPC matters. To throw some light on domestic violence matter today, since I have always been on this side where I file applications on behalf of my clients, and you've been on the defense side. So a few suggestions here that you would want to give for domestic violence matters. So one is that there is so much delay in domestic violence matters, again, despite the legislative giving a clear guideline that the matter has to be summed up in 3 months. 3 months is what the legislation says. But still, going on the defense side, it is very easy for the lawyers to prolong the matters. What do you have to say about that?
Yeah, as you said that it is very easy for the defense counsel to buy time, and because once the case is filed, the application under the domestic under DV is filed.
Yeah,
The first stage is for interim maintenance, and
right,
obviously a respondent will want to avoid the interim maintenance, because once the interim maintenance starts, it will start from the date of filing of the case. Okay, and
right,
it will go on every month. He has to give maintenance till the case ends, and thereafter, after the final judgment, also, if there is maintenance given. So certainly, if you have filed an application and you are for appearing for the applicant, it is very important that you should press on interim maintenance, and on the very first day of if the case is filed and it is kept for appearance, and because what happens is normally the respondents appear and they buy time, they say that we have to file our written arguments on the next date, and on the next date they file their written arguments, and then on the next date they say that now it is kept for arguments, and so on and so forth. They can buy time by making certain applications. Then in most of the cases, certain applications are made by the respondents to call upon the income tax returns and the job details of
right,
the applicant.
right. Because the first, the first thing that happens after a domestic violence case is filed is that, most of the people on the defense side will say that they're jobless, they have no source
Yes.
of income. So yeah, that's what happens, and this is how it is. The amount just piles on, even in the divorce matters where suddenly the respondent doesn't appear in the matter. So the amount of maintenance and the amount in the domestic violence matter, despite the warrant and everything is issued. So I was telling you, there was this one matter which I had specifically worked on, and it turns out that there was so much maintenance amount which was piled on because the husband just disappeared and he never appeared before the court. And after the final order and everything was given, he filed an appeal in the high court after sessions, and then in the high court. In the high court also, the directions were given that first you deposit this much maintenance amount, only then your appeal will be heard. But on the very next day, no, the next date when the matter was listed, again, the lawyer appears and says that they could not deposit the amount. Now, in such a case, where the applicant has waited so many years but still there is no maintenance amount, what can be done in such a situation? As a lawyer, what
And
would you recommend?
before the trial court also, and before, if the appeal is filed before Honorable High Court also, I would just go for a issuance of warrant against the accused, the respondent, for recovery of maintenance amount and the arrears, because unless the person, and that recovery should also be for that the entire amount, so that even if the person is arrested, his bail should be on only one condition, that the entire amount shall be deposited. That shall be my line of action.
Right, but that's what I'm saying, that the accused in this case was fleeing the matter. He was not in the country. He was
Yeah.
somewhere in Dubai, and the
O-
wife was in a very poor condition. She was suffering. So
Okay.
despite there being so much maintenance amount being piled up, there wasn't anything that High Court could do. Despite they just dismissed the appeal on the grounds that they could not deposit the amount. So
Okay.
so what could be done in such a situation?
Ruchika, in such situation, if there is a warrant pending against the accused for recovery, then the execution of warrant is the only way how we can go about. Because unless we issue warrant and the warrant is executed by the police, there is no way that the recovery of the maintenance amount and the arrears would be done.
Right.
Other than that, other than that, even if you have certain knowledge of immovable property of the said accused or
Right.
the respondent, you can go for an attachment in certain cases. But
Okay.
most of the time, what happens is, if the person, like in your case, if he is in Dubai and he does not have a property in India, then that becomes an issue again.
Hmm. Hmm.
If there are certain immovable property within the knowledge of the applicant, having entire details of certain immovable property, the
Right.
applicant can always go for an attachment also before the Honorable High Court or before the trial court also.
Okay.
Or
Okay.
yeah, and the applicant can file a separate miscellaneous application for recovery of arrears before the magistrate court also.
Okay. Okay. Thank you, Ravish. That answers my question. Ravish, people are asking for your email ID. If I could just type it in the chat box here. Guys,
Yeah, it is.
Ravish is there on LinkedIn. I've already tagged him in the post. You guys can check my LinkedIn and find him there.
I'm again sending my email ID.
Yeah.
I think if you have 5 minutes, I think I saw one interesting question, Ravish.
Yeah,
Was
Harsh,
that,
please go on.
I mean, it's not my question, but I saw it on the chat.
I'm
Somebody asked
sorry,
a question
Ramon.
that, uh, can the dispute between the husband and wife, can
Yeah.
he be, if there is a complaint of, 377, can he
Right.
be arrested? I think that is a very critical question that was asked by somebody. I think if you can just spend 2 3 minutes on that.
Ravish?
Uh, Ruchika, can you tell him to ask the question again, because
Yeah, Ravish is saying that in a case of 377, um, uh,
yes,
yeah, so in that case, what happens to the husband, right, Harsh? Was that your question?
I think, yeah, the person has one of the participants has asked whether if there is a, wife want to spite the husband and she has lodged a false complaint of 377. So worries whether he will be arrested, or, what is the procedure to protect the husband himself.
to protect the husband. That is your question.
Yes, I think that is the question
When
asked by somebody. This is not my question. I think it's interesting.
in any case, if you feel that it's a false case, then I would suggest a person to go for an anticipatory bail, sir. In any case, if the FIR is registered, the only way how a person can be protected, and if he is apprehending arrest, then he has to go for an anticipatory bail. And he has to keep the points before the Honorable Sessions Court judge that he is apprehending arrest and it's a false case, and he is also apprehending there might be other hardships also which he has to go through if the case is filed against him.
So anticipatory bail is the only solution you are saying?
Yes, of course. Because
Okay, thank you.
the FIL is registered, you are saying, right?
Yeah, that is what somebody had put a question. Yeah.
You cannot do. There's only medium where you can put your side is before the Honorable Sessions Court. You're welcome.
All right. All right. Thank you, everyone. So we're concluding the session. In case there is anything, you guys can write us on LinkedIn. We will get back to you. Thank you so much for joining the session.
Thank you, everyone.
We'll come again with some new topics.
Thank you.
Thank you, everyone. Bye-bye.